Hello and welcome to Unpublished Opinions, an Institute for Justice Roundtable podcast. The podcast where Institute for Justice attorneys give their unvarnished and unpublished opinions about the law. We're recording this on Wednesday, July 30th, 2025. I'm Anthony Sanders, the director of the Center for Judicial Engagement at the Institute for Justice. I've seized the microphone for this month's episode of this show, and I have two of our regular roundtable guests here to chat about their unpublished opinions. They're Josh Wyndham and Anya Bidwell of the Institute for Justice. And they have all kinds of opinions. I have opinions of my own. The Supreme Court, recently wrapping up its term, has continued to produce fodder for unpublished opinions. But we're thinking about other stuff out there too. So I thought we would maybe start with, we might talk about a case in particular, but also kind of just like the vibes these days with Section 1983, which is the Civil Rights Act of 1871, which like half of all constitutional law flows through basically these days. Anya, you are a Section 1983 expert. Would you say you are happy or sad these days, or kind of mid about how it's doing?
I'm a happy warrior, but I wouldn't say that I'm thrilled with the 1983 jurisprudence these days, although I'll tell you, the FTCA stuff is looking up. We got a really good decision against, the federal government and for actions of its employees in Martin versus United States. So there are indications that the Supreme Court is taking seriously certain violations of the Constitution or state tort violations or whatever. But in Medina, it's like you said, Anthony, I'm not exactly super thrilled with that case. The facts are, straightforward. South Carolina excluded Planned Parenthood from its Medicaid funding. And so a patient who wanted to receive her services. And so this patient, she sued basically saying that there's a federal statute that allows her to choose Planned Parenthood as her provider, and that the state is acting in violation of that statute. And the Supreme Court took up that case to look at whether, in fact, that federal statute does allow her to sue under Section 1983 for violations of a federal statute. And really, if we zoom out, why I'm not super thrilled about this is that the Supreme Court really is kind of citing a lot of Bivens jurisprudence, for example, and like expressing its skepticism in general about its power to provide remedies for violations of rights.
Right. And like the argument here is Section 1983 provides a remedy. It has very broad language. Every person who, under color of a law, subject or causes to be subjected any citizen in the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws.
Exactly.
And so they're just saying that doesn't apply here because spending or something?
Yeah, the spending clause, the statutory provision does not unambiguously confer individual federal right. And therefore, the 1983 claim cannot proceed.
Can I ask a question about this? So the whole opinion, I'm maybe broad brushing, but much of the majority opinion is framed around rights. But that struck me as kind of odd, if not formally, at least tonally, because it's not about a right? It's about benefit, a privilege. That's also covered by 1983, is it not?
So I think that's actually something that Gorsuch really narrows in on, right? And he kind of talks about sort of negative rights and positive benefits. And he's saying that there is a fundamental difference between, the Bill of Rights, for example, that protects negative rights, right? That the government cannot infringe upon that, something that is pre-existing, versus something that a statute codifies, which is a benefit. And I think really where all the skepticism comes from originally on the fundamental level is that here we are talking about a benefit and not a right, and therefore we don't feel like we need to be providing remedies
that's kind of my
that
question.
kind of a scheme.
That's like my question, though, is that like, doesn't 1983 by its text refer to things other than rights, right? So even if we think of rights as purely negative, like, could it plausibly be said that this is a privilege of some kind, or you have an immunity against the government preventing you from choosing the doctor that you want to get treatment from, something like that. I mean, I'm not an expert in like the distinctions between these terms in 1983 in the way that you might be, but I'm just curious why the focus seems to be on the word right and not the other terms in 1983.
I mean,
Pandora's box. I'm sorry.
It is Pandora's box. Yeah, but I do think so. I think what's important to underline here is that the driving reason for the skepticism is that they don't think it's a right. And that they don't think that 1983 codifies anything other than the right.
Well, and I mean, they do say also, right, like you could have a statutory right. And that statutory right could be for something that in a constitutional sense would be a positive right, like a benefit. But that you need to be super unambiguous about it, basically, because otherwise it's a Pandora's box of all kinds of stuff you could sue about. I mean, that's kind of the most I can distill, I guess.
And it's amazing to me how they're basically saying, like, yes, we have this precedent, like Wilder and Wright and Blessing, and they say that essentially, even though these cases are not technically overturned, that lower courts should not be relying on them when looking at these questions,
Resist
right?
the urge, or whatever the phrasing was.
Yes, because those cases are from the heady days, in Justice Scalia's words, when, the Warren Court, and we will come back to the Warren Court when we discuss this other topic, just putting a pin in there. But when the Warren Court was essentially inventing remedies out of whole cloth. So even though we have those cases on the books, they're from the heady days, don't pay attention to them, because now we're much more serious about grounding our jurisprudence in, common law, text, and history, which I have no problem with whatsoever. But they do seem to kind of pick and choose which common law they like and which common law they don't.
I mean, I'll just circle back. It says rights, privileges, or immunities. Which makes it seem like privileges or immunity. This is separate from, arguably, from the whole privileges or immunities clause in the U.S. Constitution, right? But just set aside, this is in a statute, rights, privileges, or immunities. So there's stuff that aren't rights that are privileges or immunities. That sounds like a benefit you get from statute, whether it's from, an immunity, like so someone can't sue you for a wrong, or privilege sounds like more like like a welfare benefit.
Right?
Yeah, I mean, I just I guess the one thing that keeps gnawing at me is that it strikes me that there's something to Justice Jackson's dissent and the way she talks about 1983 as having a broad purpose. She describes it as having a grand ambition to it. And then when you read that compared to Justice Thomas's concurrence, where he talks about sort of how narrow it should be construed, and we should re-examine the entire body of precedent and take it from where it is, which is already crabbed, and narrow it even further, it just strikes me that we're dealing with two polar opposite perspectives on the court right now on what 1983 is all about and what it's designed to do. And the majority doesn't really touch either of those poles. It just sort of continues its project of like slowly cabining the scope of 1983.
Yes, I absolutely agree. There is this fundamental disagreement about the purpose of 1983 and what it is that it's supposed to be doing. And Justice Jackson, she's a self-identified originalist, right? And she talks about... Well, but she does talk about the second founding, right? And what was it that we were trying to do with those amendments and the statute, the Civil Rights Statute 1983. Other members of the court, they don't look at it through the same lens necessarily.
That's true. Although, in other stuff Justice Thomas has said, like privileges or immunities clause, he's definitely trying to bring some of that greatness back again. But when it comes to 1983, I mean, I think some of everyone agrees that Section 1983 is supposed to be about the core rights that the 14th Amendment protects, whatever those are. But then it's like, well, what else? And it's written so broadly that it could be a lot else. I mean, it does say and laws, but are those just the civil rights laws of the Reconstruction era, or are they all laws of the United States? The next one is, Anya, you and I have talked about in the past, the Voting Rights Act. And, the Eighth Circuit has said the Voting Rights Act Section 2 isn't covered by 1983. I mean, it says it's a right. It seems kind of like an individual right to vote. The court has said a lot of important things about it in the past. Now, it's not technically, like strictly speaking, in the U.S. Constitution that you have a right to vote. I mean, you can, kind of depends how you read it, but it's not like, the First Amendment. But I think that's got to be covered by this language in 1983. And that's not even getting into the privilege stuff. So another thing about the Supreme Court is every fall. So I don't know really the tradition here. Maybe you guys do. I know every fall, the Harvard Law Review does this foreword, which is really the first article of the first issue of the volume. And they get some, well-known professor generally to write it. And it's about the court, basically, usually these forewords. I remember there was one a couple years ago that was over 200 pages, and it was like a massive conspiracy theory about libertarians taking over the government, which I look around and I don't really see that. I missed it. It sounds pretty exciting, but I missed it.
Self-identified libertarians like Elon Musk, I think, thinks he's a libertarian.
He's on the out now, so,
But again, he's not a libertarian.
Well, there's that too. So I don't know what the heck he'd say he is, but we don't need to get into that. But the latest draft forward is out, and it's our friend Richard Ray, and he has some stuff to say that I've only read through the first third of it. I think it's interesting, although I don't know how path breaking the view is, at least so far when I'm reading it. But I know, Josh, you had some strong thoughts.
I don't know if they were strong, but this has been getting a fair amount of circulation among the legal commentariat, this article, this forward. And I mean, in broad strokes, Professor Ray starts by talking about what the Warren Court sort of was, what it's perceived to be, especially among folks on the right who were critics of the Warren Court, as sort of an activist court, as an informalist court, as a court that was more focused on things like function and abstract concepts like fairness as guiding lights to, decisions like Miranda and Brown versus Board and so forth. And so he sort of sketches this arc, this pendulum swing from the Warren Court through what he calls this swing justice period where Justice O'Connor and Justice Kennedy were sort of, in the middle, towing a line, deciding a lot of cases with crucial votes, to what is now a largely conservative-dominated court that he's calling sort of the conservative Warren Court. And the sketch itself is interesting, as sort of a broad arc of legal history, if you're interested in that kind of thing. I guess the thing that caught my attention about the article, to say nothing of its conclusions, which I haven't gotten to at the end quite yet. It's a long article, and I applaud him for putting it together, because it must have taken a ton of work. I mean, just reading it, you have to have a pretty deep knowledge of not just Supreme Court history, but cultural history and political history to put together an article like this. So it's worth reading for that alone. You kind of get a nice historical summary of the last century of like how politics and law have interacted. But what caught my attention is just that, and this is a drum I've been kind of beating recently, maybe more than I should, but it feels like a lot of the article, especially the framing at the beginning, talks about like left and right, and the court is swinging from the left to the right and back and forth. Is it conservative? Is it liberal? And that way of thinking about the court just strikes me as like not terribly helpful. I mean, it definitely resonates with the kind of political commentariat right now, and the way that like the New York Times and CNN headlines on SCOTUS decisions will describe them, right, as conservative or liberal or Republican or Democrat. And I'm not necessarily saying that Professor Ray's point is that the court is like a totally political creature. I think his article is more nuanced than that. But it just sort of irks me to see these kinds of trends framed through the lens of politics, because there's a lot in the article itself about how there were features of the Warren Court that were more functionalist, and now the current conservative supermajority, as he's calling it, is more formalist. And like these seem like the actual like the things that really do matter in terms of deciding outcomes of cases. And I guess one of his points is that like as the political poles on the court kind of shift back and forth, you see like different these same like camps trading hats almost, right? Where you now have like folks on the kind of quote unquote left using some of the tools that maybe folks on the right would have used to criticize the Warren Court, and sort of vice versa. That's an interesting observation, but I just don't think it cuts to the heart of what's really driving a lot of the justices right now. It feels to me like what's really driving them is like their judicial philosophy and the way that maps onto the issues of the day, right? And like maybe those judicial philosophies are themselves rationalizations for political priors. Like I'm not going to accuse anybody of that, but that's certainly a common phenomena out there in the world, right? That like people come up with their philosophies in part to rationalize things that they wanted to be true as a matter of politics or law or anything else. So it's possible that they're just sort of inextricably bound up in a sense. But I guess my point is just that it feels like the fundamental is not the motivations and is not like us guessing about what their politically preferred outcomes would be, but instead, like, are they originalists? Are they purposivists? Are they formalists? Are they functionalists? And like, how does that itself drive, the arc of legal history? And so I wish the article was framed more in those terms, but I see why it was written the way it was written at the time it was written.
So I agree with you. And if this article was written by somebody other than Richard Ray, and really somebody other than someone with deep understanding of the Supreme Court, I would just dismiss it, because I'd say, yes, you shouldn't be framing it this way. This is exactly the discussion that I have with my non-lawyer friends when I tell them it's not that the court wants to rule for the Trump administration. It's that it's just rules for the Trump administration when it happens that its ideological commitment or its philosophical commitment is aligned with them. But because it's Richard Ray, because it's somebody who, clerked for Kavanaugh on the DC circuit and then clerked for Justice Kennedy on the Supreme Court, it feels like he has an intimate understanding of how the court works. And it's kind of disturbing to me that a person like that is describing it this way. It kind of gives more credence to people who do say that the court is divided politically. And I very much hope that it's not true. I, very much hope that they are divided philosophically. And I'm totally fine with that. We can have honest philosophical debates. But when somebody starts describing it in political terms, and that somebody is with a good insider knowledge of the court, that's kind of disturbing.
Well, I think so. I'm going to push back a little bit on both of your views, although I think you can square it maybe with
do
what
it.
he's saying. And I have not read. I'm really interesting so far, but I've only read the first third or so of the article. But the broad history part is really interesting. So I think I don't know if Professor Ray would say this, but I would say that, to Josh's point about how you hope that the justices are still like just doing their political philosophy, or not political philosophy, their legal philosophy, and then that is driving these outcomes that then we put on a left-right spectrum when it's convenient. Although there's a lot of cases that, at least in this section I've read, aren't mentioned, like a lot of Fourth Amendment cases and other ones that kind of muddy the waters, right? And of course, there's muddy waters when we're talking about a political spectrum. But I think it's more that, so, right, a big critique of the Warren Court, which I think is entirely accurate, is that they weren't paying attention to text enough. They weren't paying attention to things like original meaning enough. It was a bunch of politicians kind of being loosey-goosey. And so in response to that, if you don't like what's happening, maybe it's just the political outcomes from those cases, but you don't like what's happening, you are going to start being in favor of stuff that's the opposite of that. Like textualism. Hey, if we had more textualism, if we didn't go into like congressional purpose and that kind of stuff, we would not have those outcomes as much. Okay, well, let's be for that. And I mean, a cynic could also say about originalism and, the rise of that movement in the 70s and 80s and all that. So by the time you get to now, where you have those kinds of people are a majority on the court, and then you get things coming to them, like, say, Section 3 of the 14th Amendment, that when you adopt those tools that they have been in favor of for decades, and to some extent got them into power, and they start getting outcomes they don't like, right? The shoe's on the other foot, then you will have them start inextricably, maybe they don't even think about doing this, but it's human nature. It moves them towards being more what the Warren Court used to be, where you're more into purpose and what's the general idea here, and maybe being a little more loose about your history or whatever it is. Not even necessarily, I put that in a more pejorative sense, but not necessarily bad things, but just different ways of doing legal analysis, that they're going to move in that direction. Now, he's not the first one to say this. I know Jack Balkin's written about this recently, and like that this happens when people use history in law. And so once you get a majority, you start doing things differently than when you were a critic. But I think there is a lot to that when you look at it through a political lens, to the extent that justices feel, or other judges feel, they're part of a political movement, which, although many will say no, a lot of them really do feel they're part of a political movement.
Yeah, that strikes me as all correct. I mean, I don't disagree with anything that you said, and I find it striking that one of the things that he said, he said he originally thought to call them the Lochner, like kind of like a conservative Lochner court, rather than a conservative Warren, which is an interesting, it's interesting to say that you would call them that if it didn't have the kind of like heavy-handed connotations.
Yeah, but then he says, but that kind of doesn't make sense. I mean, he doesn't explain why, but I think I know why. But because like these justices are not into, economic substantive due process, or all that much different with the Commerce Clause. So it kind of is it would be misleading if he used that.
Yeah. But I take it that what he's getting at, though, with these sort of like proper noun court era phrases of like the Lochner era court, the Warren Court, the conservative Warren Court, is that they're ideologically driven like blocks of majorities that span like significant portions of time in Supreme Court history, and therefore have the ability to drive not just like momentary change, but like decades of legal change and trends. And I think, I hesitate to put these words in his mouth because, as I said, I haven't finished the article, but one of the things I was getting is that he actually finds this pendulum swinging back and forth kind of like imperfect, but valuable, where you just have this like decades long, almost like discourse between generations about the tools that are proper in legal interpretation. And the ways that those can wax and wane often stem from, as you say, Anthony, maybe motivations of like, oh, I didn't like the results of those prior courts, so let me like pull these tools out of the toolbox and start using them again. But it's interesting because it highlights the different tools that are available and continues a dialogue over the course of time about which ones have a place in our legal system and which ones don't, right? Because you get pretty strong. I mean, just take the CASA decision, right, where you have the Justice Barrett's majority decision, like really, going at it with Justice Jackson in dissent about the methodology employed in coming to the conclusions they came to, and like it's pretty hot. It's not a cold discussion.
CASA is actually a nice transition to class actions, but before I go there, just want to say that today's opinions are written so much better than opinions during the Warren Court. And it does feel like there is something about today's culture that, judicial or, jurisdictional culture where the judges, they just feel like they need to explain themselves better and they have to be disciplined about, how they're interpreting the law and what tools they're using, just laying it out there. If you read opinions from the 60s, and some of them I will go to my grave defending, right? But if you read those decisions, a lot of them are very sloppily written, where it's just like, yeah, this strikes me as the right outcome. Ta-da!
Yeah, I'm really happy you're saying this, because I didn't know if I should be the one to go off on a limb and say that I actually like a lot of Warren Court decisions, but I think the outcomes are correct and often defensible legally, but that they weren't properly defended in the decisions.
Yes.
And that really irks me.
Yeah.
Right. And today's decisions are much more defensible. If you just read them, you can see, okay, here's the process that the court went through.
There's a real show your work culture now.
Yes. Yes, that's a great way to put it.
Except on the interim or shadow or emergency docket, whatever you want to call it. There's less of a show your work culture there.
Yeah. Well, and I would add, going back to Justice Jackson's dissent, which in spirit I agree with, in the CASA case, I think there's also when judges have time to write things, and that was a case which was argued May 15th and had to get out by the end of June, where maybe not everything was properly edited and thought through. And so that's why the prose is not the kind that you're talking about, Anya, that we would want.
Right.
Yeah,
right.
There was a lot of broad brushstrokes about like justice and that, but she could have used a little bit more tying it together. So.
Well, and that brings us to the kind of repercussions of the CASA decision, right? So there's been a lot of worry in terms of universal injunctions and the kind of important tool that is being taken away from the litigants, from plaintiffs. There was a breakout star in the oral arguments, and that breakout star was class actions. And this is something that we're kind of seeing now, because if during the oral argument, Justice Kavanaugh, for example, just kept saying, but how about class actions? Wouldn't class actions help you to meet, to get to the same result, especially when it comes to the kind of constitutional violations that we're talking about here, right? Or constitutional rulings, broad constitutional rulings that we're talking about here. And he even mentioned putative class actions, right? This idea that, yes, you're right, class actions themselves are really difficult to certify, but what if, a court gets to putatively certify class and then order an injunction based on that? How would that work? And we've seen that work pretty well actually in that very case involving the citizenship question.
So far.
Yeah. So far, yeah. But like several weeks later, you have a judge certifying the class of kids who are born here to parents who don't have papers or who here are temporarily, right? And then issuing the injunction, which is still in place, just like it was before the case got to the Supreme Court. And then, of course, we saw another putative class action and the Supreme Court with the Tren de Aragua gang, right? When they stopped deportations until due process is complied with. That's also a class action, right? And so it's kind of interesting to kind of think through this, because my biggest worry with universal injunctions was very much something that Kelsey Corcoran, friend of the show, kind of argued, where when you're talking about these clearly unconstitutional actions, what are the tools for dealing with those that are not just universal injunctions? And so far, it seems like class action has been doing okay, but obviously the jury is still out.
Yeah, well, I mean, that was a big, listeners may know I've written a bit about the fall of universal injunctions and had a bit of a sky is falling to my rhetoric, perhaps. And
Anthony is known for his fiery rhetoric.
Fiery Minnesotan rhetoric.
Yes.
Those guys.
I'm not originally from Minnesota, so be that as it may. But I've said that that things are going to be really bad in this area because we don't have universal injunctions before, and I've gotten pushback to, hey, there's class actions. You could get the same kind of result from class action where you order the government to not enforce the law against people beyond just the named plaintiffs because you have the appropriate class. And I am not at all surprised that there are being classes certified in these in this matter about birthright citizenship, because you have these major organizations, not IJ, but places like IJ that are well-funded, that are very organized, that have good lawyers, that are, have a cause where there are a lot of donors who help out with that cause, and plaintiffs' lawyers who know what they're doing. And so you're going to get that class. And it's also the type of class where, it's not too hard to figure out what the class is, right? Children born to, as you said, those kinds of mothers. But, and so, we do class actions at IJ. Maybe we'll do more now because of this ruling. From a public interest standpoint, it's better to have a ruling with a class than just one plaintiff. So fine. But what I worry about is there are plenty of constitutional cases brought where you don't have a major nonprofit public interest law firm bringing the case. You have plaintiffs' lawyers who, are just hoping to maybe get some attorney's fees at the end of the day. Maybe it's a paying client, maybe not. But there are constitutional cases where you have paying clients, like corporations suing about whatever. And in those cases, I worry that the addition of trying to turn it into a class action, either it won't work for whatever reason, because the class can't be identified, or numerosity, or what have you. But usually you can figure out a way to do a class. More it's that class actions can be super expensive. And so if you're just, a small law firm and you're doing maybe it's pro bono, maybe it's you're hoping for some attorney's fees, maybe you're getting paid, and now you have to do a class action to get that kind of relief, you might be less into doing it. And so either you're not going to do it, or you're just going to do the kind of case that all these critics of universal injunctions want us to do. Just one plaintiff asking for an injunction about that one plaintiff. Fine, you're going to get that one ruling, and it's not going to do all that much in the grand scheme of things unless the government's dumb enough to appeal it. So that's what I'm worried about. And I think the jury might be out for a while before we see, if there's a difference. Or maybe I'm blowing hot air.
I think Justice Alito is kind of worried about class actions becoming a thing, because he was pretty clear in his separate writing.
Well, he said basically we're not going to change the rules on class actions just because we got rid of universal injunctions.
But hey, provisional certifications are very interesting.
Yeah, well, so that's you're putting your finger on the worry that I've heard more than what I just articulated, which is when you're looking for preliminary relief, so preliminary injunctions, right, TROs, then you need this putative class thing, and that might be the trickiest part. I frankly am not as worried about that. I think that is part of the whole that is part of what people see with the whole universal injunctions debate, was the federal government coming up with some new kind of crazy, maybe not that crazy, but often crazy regulation that is then enjoined on a nationwide basis, and we get the whole nationwide injunction thing. I'm more worried about like, you know, a stupid new law at the city council level.
Right. Right.
But the putative stuff, yeah, because by the time you adjudicate the whole thing, the administration like is out of power and it goes away. So who cares about a final judgment?
Right. But I totally agree with you on the local level and all the cases that we won't see.
Yeah.
It's the kind of thing that bothers me with the immunities.
I mean, do you think I'm right about that? About the, class actions are they're super expensive compared to just a normal lawsuit?
Absolutely. And even the reputation of them being super expensive is already detrimental, right? Where lawyers are not even going to want to touch on in the first place.
Yeah.
And so won't even bring the lawsuits.
Josh, are you someone when you hear like, oh, we got to make it a class action, you're like, uh-oh.
Well, my first thought is I wish I didn't have to do that. Honestly, this is an aside and you know, maybe we cut it from the episode. Maybe listeners care about this, maybe not. But I am actually very frustrated by the CASA decision for another reason, which is our North Carolina con litigation. To give listeners a high-level overview.
Go for it.
Yeah. So where to start? So we have a state constitutional challenge to North Carolina's Certificate of Need law. And a con law is basically a law that requires you to get a government permission slip to provide certain healthcare services. And the state has broken up different regions and has said that, you know, certain regions need new healthcare and certain regions don't. And our client happens to live in a region that the state has said for like 20 years doesn't need any new healthcare services. And so he is shut out of the market in his region. So we say that violates the state's anti-monopoly clause. You know, the one hospital in this region that gets to operate has a monopoly legally, right? That seems pretty bad. Let's sue about that. So the issue is North Carolina, a few years before we filed our lawsuit, adopted this new 3-judge panel system for adjudicating facial constitutional challenges to statutes. But at the time we wanted to sue, the panel system was not functional. Like panel appointments took forever. And basically what happened is if your case was going to go through this panel system, it ended up in purgatory for an indefinite period of time. So we said to ourselves, well, you know, we want our client to get relief. This is definitely a constitutional violation. Let's bring an as-applied challenge. Because at the very least, you know, as applied to his circumstances, you got one hospital in his region. He wants to provide services. Like as applied in that context, there's a monopoly, right? And so that's the case we brought. The case goes all the way up to the state Supreme Court, never goes through the panel system on the pleadings, right? So we're appealing the dismissal of the case. And after oral argument on the constitutional issues, after, getting discretionary review in the court on what we thought was a cutting-edge constitutional theory that it was going to finally resolve, the court asked for supplemental briefing on had we actually brought a facial claim. Because we were seeking declaratory and injunctive relief against the enforcement of the con law as to him. And the court's theory was, actually, you have brought a facial claim because the reasoning you're asking us to adopt in holding that you've stated a monopoly claim would apply equally to the rest of the con law. And so if we adopt your reasoning, we're basically saying the law is unconstitutional in all of its applications. And so you have to go all the way back down and basically start the case over and go through this panel system, even though you pled it as an as-applied challenge. And the reason I mention this is not to say that like CASA is directly on point here, but I'm kind of frustrated at the shifting judicial winds because, you know, we're here receiving a message from the state high court in North Carolina that, oh, no, you know, you've pled a case that whose logic extends far beyond your client, and therefore you've got to go through this system for facial challenges. And you have the Supreme Court saying on the opposite side of the spectrum, in fact, like relief only applies to the parties before the court, and like who cares about everybody else? It's all about the party requesting relief before the court, and like courts don't have equitable authority to like go beyond that. And so it's just one of these things where I feel like I'm being tugged around, and the next thing that's going to happen in the case is somebody's going to cite CASA and say, well, actually, no, you can't get facial relief because courts don't have equitable authority to do this anyway. And here I am, the plaintiff's lawyer, just trying to help my client.
So isn't the difference, though, so this, I might be very pedantic, there's a difference between a universal injunction and a facial ruling.
Kind of.
Right? So a district court can say, facially, this statute is unconstitutional, and so I'm giving an injunction to not enforce it against you. Period. Who cares?
I think that's fair, although I worry that the judicial winds are moving in the direction that facial challenges can't be a thing because courts don't have authority to...
So, but who set up this? Who set up this 3-judge system?
Who set it up?
Yeah.
The state of North Carolina in response to school choice litigation that IJ was involved in.
So was it the legislature?
Yes.
So the argument, I guess, has to be the legislature unconstitutionally created this system that would do unconstitutional rulings.
I suppose so. I think it's, I guess I'm just frustrated because Justice Thomas wrote in, I think it was Net Choice in a concurrence, was it last year? I'm getting my dates mixed up, but didn't he write that like facial challenges like should be re-examined, like there shouldn't even be a thing because courts, it's advisory if it runs against anyone but the party before the court, and like that really does rhyme with the logic of the Casa decision. And so I'm just sort of concerned that I'm going to get back to the state Supreme Court in North Carolina and I'm going to hear the opposite of what I heard last October. So round and round we go, everybody.
That's a sample of our litigation meetings that we have as IJers.
Come work at IJ.
If anyone want to know what we talk about, that's basically it all day. I think we might be, I want to talk about Humphrey's executor and all that, Anya, but I think maybe we're getting a little on the longer side. So we'll save that. We'll have that be a teaser for another day. I'm sure that issue is not going away. Humphrey's executor and appointments clause and who is the administrator of Doge.
By the time we meet next time, Trump is going to fire Jerome Powell.
Yeah, well,
and then it will really be timely.
We'll be back on the gold standard by next time. So it'll be.
Well, I leave those heady issues to y'all. Although Anthony, isn't it this time to do our what you consuming?
Yes, that's what I'd like to transition to. Is Josh, what are you reading, watching? So the rule is a legal thing and a non-legal thing
that we have been consuming recently.
Yes.
Okay. Let's see. Should I do both of mine first, or let me do my legal one first, then kick it to Anya, and then we'll do the non-legal. And I hope you do one too, Anthony. My
maybe
legal one was, I wish I had the name of the case in front of me. Although everybody at our office has probably seen this at some point by now. Oh, Johnson versus Dunn, the sanctions decision out of the Northern District of Alabama by Judge Anna Manasco. Do you guys know about that one?
I know about it. I didn't know the name of the judge. That's a...
Yeah, well, she has it. If you Wikipedia her, she has
a
doctor of philosophy from Oxford, and then she went to Yale Law School. So she's kind of awesome. But so I mean, just for listeners' sake, this was a very, very lengthy sanctions order down in Alabama about the use of AI to basically lawyers use ChatGPT to come up with case citations, and ChatGPT had what the court called hallucinations and basically made up cases. And what's interesting is that this was a discovery dispute, and the propositions of law for which the citations were invented were like pretty anodyne, like normal propositions of discovery. Like it wasn't controversial stuff. And so you wouldn't have thought if you were opposing counsel maybe to like check the cases. And yet the court really blew up on these attorneys because I guess in the past there had been the court had this whole string side of decisions about how, look, like the point of sanctions is to deter misconduct by lawyers. You have a duty to tell the truth and to cite unless you can't cite knowingly false things in court. And there was this whole string cite in the decision where the court said, look, attorneys have been getting fined all over the country for this. It's not working. So we've got to do something else. And so you really have like a 50+ page like bench slap from this judge about this needs to stop. The use of AI to like lazily make up citations has gone out of control. And lawyers need to remember their duty to the court, their duty to their clients. And like, it's not too much to ask that people who sign briefs ensure that the things written in those briefs are true and not just fully fabricated. So I commend that to your attention. especially if you're a law student or a practicing lawyer, about the risks and perils of using AI too casually in your legal research.
It is so eloquent in giving you answers, right? I tried once to ask it something, and it came up with these paragraph-long explanations with full-blown cites.
Yeah.
And I thought, that's it. The work is done. All I need to do is just to actually check the cases, and I'm good. And so I just started trying to find those cases, and they're non-existent.
The best is when you ask it. So I've done this too, Anya. And the best is when you ask it, like, where are you getting that quote from? Because it's not in the case that you cited, and it will say, "You got me." Sorry. And then at one point, I wish I could pull it up for the listeners because it's so funny. At one point, I said, "You realize," to the ChatGPT, "you realize that I'm a licensed attorney and an officer of the court, and that I could lose my license for citing the cases that you have told me to cite." And it was like, "I'm so sorry. I will never do this again. I'm sorry that I've lost your trust. I'm going to work to gain it back." And I said, "Great, work to gain it back. Give me case citations with real quotes." And it said, "Stand by. I'm going to work really hard on that for you." And I never heard back.
Oh, that's funny. That's beautiful. It's just, it lures you into like the sense of confidence. It's giving you these full-blown answers with like logical reasoning right there, and it's all complete BS.
It's interesting though, because the conclusions are often correct, but you can't piece together, you can't connect the dots of like.
Well, I bet those aren't the dots that it's using. It throws them out there, and how it thinks the conclusion is some wider set of data, probably.
Yeah. Anyway, that was my legal consumption of the morning.
And you, Anya?
So I want to highlight an article by now a USC professor, Matteo Gotti. And I hope, Anthony, we can have him on short circuit to talk about this paper.
Okay.
It's called Section 1983, a strict liability statutory tort. And he argues that the judicial rewriting of Section 1983 has undermined its effectiveness and diverged from the Reconstruction Congress's intent. Sounds familiar? He argues that Section 1983 should be interpreted as a strict liability statutory tort. So that's a teaser for you. I hope we have him on short circuit so he can talk about it in detail.
So he thinks originally it was going to be strict liability for all people acting under color of law?
That's right.
And this is what you and Patrick argued in your law review article about constitutional torts generally, right?
That's right.
Matteo
Gotti.
Giacomo, that is.
All right, little teaser there for the audience. We'll work on talking to Matteo more. I have a book I've been reading off and on, The Gun, the Ship, and the Pen, which is by Linda Cooley. And I'm trying to read here without my new reading glasses, but constitutions and written constitutions and the making of the modern world. So it is basically a history of written constitutions, which doesn't sound all that new. But the interesting thing about it is she puts the U.S. Constitution and early state constitutions kind of in the flow of history of that time, which interestingly enough began in Corsica in the 1750s. There's this dude who is a revolutionary in Corsica, and like it didn't work, but he had a written constitution, and then that kind of idea was copied elsewhere, and then how the coming of modern constitutions, written constitutions, was kind of happened because basically world events and a lot of it being warfare. And so it gives you a different perspective than we usually have in our own U.S. constitutional history. So I recommend. But so outside the law box, Josh, what are you doing with your time?
So I just read a how do you even describe this? Sort of a gothic fantasy murder mystery novel. Actually, Bob McNamara recommended it to the office, and we had a kind of email thread with some book recommendations. And so Bob is IJ's deputy director of litigation, and it's by Robert Jackson Bennett. It's called The Tainted Cup, and it is. I give it 5 stars on Goodreads. I mean, it is tremendous and delightful and page turning. And to give you like a very, very short flavor of it, It's sort of this society that lives behind a series of ringed walls that lines the ocean. And every, what they call wet season, there are these creatures called leviathans or titans that come and approach the walls and essentially try to knock them down and make their way into the empire's inner rings. And so the outer ring people tend to be poorer and more like military and that kind of thing. And the inner ring people are the emperor and the gentry and the aristocrats and that kind of thing. So it's a very it's a book about politics and man's relationship with nature and war and murder and trying to uncover a mystery that has threads that go all the way to the highest levels of the empire. It's really, really fantastic. The writing is delicious. It's just a great read, and I'm going to read the second book almost immediately.
Wow. And what is it again? Something
it's called The Tainted Cup by Robert Jackson Bennett, I haven't read any of his other work yet, so I don't know a ton about him, but it's a name I've heard before, so I'm excited to explore more.
Are you reading it or are you listening to it?
So after my son was born, I shifted to combined audiobooking and reading. So I buy a physical copy of every book because I just have to read books by holding them. I still like doing that. But I will audiobook that same book through my Spotify membership, while working out or whatever. So I make my way through it faster, but I still physically read books.
So you read part of it and listen to part of it, but it's not like you double up.
I don't double up.
I've heard of people who double up, and I think, wow, they must have a lot of time.
No, I don't do that. I just, I get home and I read a chapter and then go to the gym and listen to a chapter and so forth.
Anya?
I want to recommend the Mark Twain biography by Ron Chernow. It's really fun, especially if you only have time to read one chapter, because it got a reputation for being rather a heavy book. Read the chapter on Mark Twain publishing Ulysses Grant's biography. It's the most amazing thing. He is basically, first of all, undercutting a big publishing company, and he offers Ulysses Grant more money for the book. And then he understands that Ulysses Grant has only very limited time to live. So he essentially develops a plan. He hires a person who, at some point, Ulysses Grant basically is too exhausted to write, so he hires a stenographer who basically listens to Ulysses Grant and writes things down. Then he has this plan of promoting the book where Union soldiers are actually knocking on the doors and asking people to subscribe to the book. And Ulysses Grant, of course, is fighting against time because he is bankrupt because of that scheme that his son got him involved in, and he wants to make sure that his children and his wife have some money after he dies. So he is basically fighting against time to write the damn book. He dies 10 days after he finally hands over the manuscript to Mark Twain to publish. And it's the most fascinating story. There are two super famous people in America, but somehow the relationship between the two of them has not really been scrutinized.
Yeah.
And I think if anybody wants to make a movie, if a producer is listening to me over there, all you need is to focus on that story of Mark Twain publishing Ulysses Grant's book. By the way, at the time when he no longer wants to be a Republican, he doesn't like all the corruption that's happening. He disagrees with all the corruption that was happening in the Ulysses Grant administration. But he's totally taken with the man. He ends up falling in love with him and having the biggest respect for him. And the biography ends up being, till this day, the best known, best written biography by a US president. So it's really cool.
Biography that covers the story of a biography.
Yeah.
That's right. That's
So
right.
I know about Grant's side of that story, and I know about some of Twain's history at that time, but I didn't know a lot of what you just said, Anya. I mean, I need to read the book, but it sounds but is that during the period too when Twain was really in debt? And so he had to do all these ventures to pay off his debts?
No, that was actually before then.
Oh,
that was
okay.
before then. He was really frustrated with his publisher, and he created his own publishing company so he could publish Huckleberry Finn on his own.
Okay.
At that time, he found out of what was happening with Ulysses Grant. He genuinely thought that Ulysses Grant was being ripped off. He genuinely thought that the Century Company was not offering him enough money. And so he's like, hey, I have a publishing company that I essentially created to publish my own books. Why don't I publish yours. And then actually the success of the book, Ron Chernow basically says, the success of the book was almost to Mark Twain's detriment, because then he kind of stepped away from the writing and started publishing other books. Like he published a book by a pope. He thought that the Pope's book would be like a complete success, but nobody cared. But Ulysses Grant's book was genuinely a success. And the other super crazy thing is that the two of them almost crossed paths on the opposite sides of the war. Mark Twain fought for the South. He was in the militia in Missouri for like 2 weeks at the time when Ulysses Grant was coming through Missouri. So they actually almost crossed each other. And Mark Twain used to joke that, he was so scary that Ulysses Grant decided to go the other way.
So I know later in the war, he was working in Nevada as a stenographer because he was at the Nevada Constitutional Convention. But I didn't realize he would, like, at the very beginning, he was fighting for Missouri.
He was fighting for Missouri, and then he ended up, obviously,
But Missouri
being
didn't
a big
secede.
Republican.
Was it like when Missouri was thinking of
It was
seceding?
a state militia. It was essentially a state militia. So it wasn't like organized.
So they were on the Union side.
Right, but he was fighting state militia on the southern side.
Oh. Wild.
So they were like, putting together these bands of groups because Missouri wouldn't take the side of the South.
Right.
They basically put together those groups to fight on behalf of the South.
Well, I have something much less interesting, perhaps. I've been reading through The Female Quixote, which is a work by Charlotte Lennox from 1752, which is basically a takeoff of Don Quixote, but it's a woman. And it's super fun. And it's about this woman who all she reads is romance novels, essentially, from the time. And her father doesn't have her have any other contact, and so she thinks the whole world operates like a mystery novel, and then she acts all super weird, and it's hilarious. So I just don't like that the S's, it's the old font. So what are those things called that look like F's but they're S's?
I don't know, but I hate them too.
Yeah, and so I'm always in my mind having to translate them into S's to get through.
This is a personal picadillo, but several of my cases have to do with the original meaning of the word possessions in state constitutions. And imagine reading possessions, many S's, all looking like F's. Puffeffins.
So Wikipedia says it's called the long S. So, also known as the medial. So there you go.
Okay.
Anyway.
That's kind of the weird thing in terms of like what comes with the time, right? Like Mark Twain specialized in accents, right? So he would be, as he's writing like Huckleberry Finn, right?
Yeah.
He would be using like the accents of the time and the specific ways of talking at the time. Or like he wrote like this one short story about a woman telling him her story. And it's just so hard for me to kind of like the manner of speech that's different from standard, or like the manner of writing that's different from standard.
Right, because you have to translate in a sense.
Exactly.
Yeah,
exactly.
Yeah.
So that essence is kind of what you have to do too.
Yeah, it's a different font or different script almost. But anyway, I'm getting through it. It's good. And thank you guys. Thanks everyone for listening. And, that's just like your unpublished opinion, man.